I've represented landlords for 20 years now, and the issue of bed bugs is causing me and everyone at my firm and everybody else in the legal community that I know of in this area to sort of scramble to figure out what the heck is going on. There's very little help that the law is giving us, and that's not because they don't want to, but because, as the state senator mentioned earlier, everyone is sort of trying to get their arms and their heads around this issue. And from my perspective, being a landlord guy, I get many calls on a weekly basis about bed bug issues. It's as everyone knows who's a landlord here and Mike will talk about the tenants, everyone knows we don't want them. We don't want them at our properties, and we want to get rid of them as quickly as possible. And we're all trying together, trying to figure out how to do that. There are some folks I see here from the Cleveland Housing Court, and in discussing with them, they're still trying to figure out some of these issues. The existing law does give us some guidance. And in Ohio, back in 1974, we passed the Ohio Landlord Tenant Act. And since 1974, it's pretty much been unchanged in terms of what we're going to be talking about. And you'll see on the screen that we're talking about a couple of sections of the code. The first one dealing with what the landlord responsibilities are with respect to tenants, and then what the tenant's obligations are with respect to the landlord and to the property. Specifically, Ohio Revised Code section 5321.04 specifically states that a landlord is charged with the responsibility of complying with all applicable housing, building, health, safety codes that materially affect health and safety. They are to make all repairs and do whatever is reasonably necessary to put and keep the premises in a fit and habitable condition. They ought to keep the common areas of the premises in a safe and sanitary condition. So you can see some of the wording there in the law that was passed in 1974 and that we still work with today. You can see where the bed bug issue may fit into a landlord's responsibility with respect to what they need to do. Reciprocally, there's also responsibilities of the tenant under 5321.05, and the tenants have responsibilities with respect to the property as well, and they are to keep that part of the property that they occupy and use in a safe and sanitary condition. They are to dispose of all rubbish, garbage, and other waste in a clean, safe, and sanitary manner, and the tenant is to keep the premises in a safe and sanitary condition. Again, some of the wording there can be used to fit the bed bug issue, and we'll talk about that in a second. There's no case law on this, folks, okay? The one case that we found, okay, is from 1930, okay? Other than that, there's nothing, okay? This is a new area of the law. Lawyers for landlords, lawyers for tenants, magistrates for the courts, judges for the courts, they're all looking for guidance, okay? And so far, Ohio has not given us a lot of guidance on the issue of bed bugs, okay? The one case we found, a March 7, 1930 case out of Cincinnati, basically involved a landlord had sued the tenant for unpaid rent. The tenant had filed a counterclaim alleging that when he went into the possession of the premises were infested with bed bugs. The court noted that there was no guiding case law in Ohio, no kidding, and ruled that it was a constructive eviction. Now, for purposes of this discussion, you really don't need to know what a constructive eviction is. Suffice to say that something happened in the property that forced the tenant to leave. They have no choice but to leave. The court ruled that an innocent tenant has the right to presume when he enters into a lease he will get a dwelling that is fit and habitable. Well, that's probably where Avery Friedman, who drafted the Ohio Landlord-Tenant Act, got that language that he put in the 1974 Act that imposes an obligation on the landlord that you got to provide premises that are fit and habitable. And when there's a pest infestation, then it's not fit and habitable. So that may be a violation of the landlord's responsibility. And that's the language that Mike is probably going to hit upon when he says that if you have a pest infestation and it's not clear who caused the infestation, landlord, you have an obligation to provide premises that are fit and habitable, okay? And you haven't done that. And my office, when we discuss this, we sort of conclude that it's all going to come down to a habitability issue. As the state senator aptly pointed out, there is no pending legislation in the state of Ohio addressing the specific issue of liability for bed bugs in the area of landlord-tenant law. Although I submit that hopefully he would take back to the General Assembly the need for some type of amendment to the Ohio Landlord-Tenant Act to address this issue. Hopefully, those are one of the things that we can talk about. What do courts do, or what do states do when they're silent on the issue? Well, if you're a court and they're silent on the issue, they look to the other states, okay? How have the other states dealt with this bed bug issue? Well, there are other states that are sort of a little farther along than where we are in Ohio, and we're going to talk about those right now. In February, as of February 2011, Illinois, Maine, New York have all adopted bed bug related laws, okay? As of earlier this year, there were 11 states considering bed bug legislation. Again, Ohio, I don't believe is one of them, aside from the resolutions that the senator alluded to earlier. Several municipalities have addressed or are looking into proposed ordinance regarding bed bugs. Not surprisingly, they are large metropolitan areas. New York City, Jersey City, San Francisco, Boston, Cincinnati, Detroit, all of those major urban areas are dealing with this issue because we ain't the only one that got bed bugs. And they have them worse than us, I think. I love that. I'm not responsible for that. Thank you, Tom, for that. Or maybe it was you, Mike. But bed bugs love New York, right? Other states have looked at this. There's some cases dealing with this in New York City already. One case where the tenant refused to pay his rent for 6 months because of a persistent bed bug. Basically, the court ruled in favor of the tenant, and that decision reversed a decision going back to 1908, which addressed maybe not a bed bug, but basically the general proposition that a tenant must pay rent regardless of a vermin infestation. So this case law is developing, folks. We don't have all the answers for you today. There's a new bill in New York City that requires a landlord to inform incoming tenants of the property's bed bug infestation history for the previous year. This includes premises rented by the tenant in the building in which the premises are located. Other states, Maine, for example, landlords are required to contact a pest control agent within 10 days of determining there is an infestation. They must employ a pest control agent that carries current liability insurance to promptly treat infestation. They have to disclose to prospective tenants if an adjacent unit is currently infected with or being treated for bed bugs. They cannot offer for rent a dwelling unit the landlord knows or suspects is infested with bed bugs. You know, so the point here is that other states are dealing with this issue, and Ohio certainly can look to those types of things. New Jersey passed a statewide bed bug law in early February of 2010. This bill states that landlords of multiple dwelling units must provide pamphlets to tenants and other information on bed bugs and preventative methods. Landlords must have bed bug infestations exterminated directly after learning about them. Landlords who do not take immediate actions may face fines of $300 per infested bedroom or $1,000 per infested common area. Does anyone who's landlords out there raise your hand? You're getting a general theme of what the other states are doing, okay? It's not necessarily the tenant, okay? It's the landlord, and it may be as simple as who can best bear the financial burden of this issue, and they've decided that it's not the poor, lonely tenant that Mike represents, it's the gouging, offensive, money-grubbing landlord that I represent. We've tried to come up, and we're sharing with you intentionally some things that we're thinking about in our office, okay? And again, it remains to be seen how we do on the case law on this and the practical cases that the courts will see. Some courts, it won't surprise some people to know, are leaning certain ways, okay? Some courts lean certain ways on different issues, and we always have to take that into an account. What we're trying to do now for our clients is we're trying to put a plan together in terms of a pest management, we call it a pest management plan and addendum. And it's a document that we've created and have prepared and are getting out to our clients even as we speak, suggesting that they adopt this addendum as part of their lease documents when a tenant enters the property, okay? And the pest management addendum and pest management plan and addendum basically outlines what we feel the landlord's obligations are going to be and what the tenant's obligations are going to be. I personally feel that this issue may come down to not necessarily a causation issue, i.e., can we determine who caused the problem, but I think a lot of the cases are going to involve, after the problem exists, what is the landlord or the tenant doing to remediate the problem? Is the landlord doing all he can to remediate the problem? Is the tenant doing all he or she can to assist the landlord and their pest control professional in eradicating the problem? My personal feeling that if the tenant, if we can't show that the tenant caused the problem, we can at least document from a landlord's perspective what we need to do to remediate the problem, and if we can establish that the tenant is not cooperating with the landlord, is not taking reasonable measures in association with what the pest control professional is recommending they do to remediate the problem, okay, then we feel that that's a breach of the tenant's obligations under 532105 and would warrant an eviction. Document every step a landlord takes when addressing bed bug complaints. Address bed bug complaints immediately. Our pest management plan and addendum basically imposes an obligation on the tenant to notify the landlord immediately when there's an infestation. Well, we have to educate the General Assembly. We have to educate the judges and the people who are hearing these cases that is a financial burden. A $3,000, I don't know if you know much about the availability of these funds of these buildings and what the landlords are facing in terms of a financial burden that these pests cause, but it is tremendous. It is tremendous. You mentioned the amount of $3,000. A $3,000 on a multifamily housing project is catastrophic, okay? Because the amounts that they're dealing with are the budgets that they are dealing with are so tight already that if you impose a $3,000 financial burden on a landlord to eradicate a bed bug infestation, you have to understand, Senator, and the people who work on the tenant side of the street, that this is a catastrophic financial burden for the landlords. So I understand that. Well, I proposed management plans, pest management plans. By the way, we've come up with pest management plan and addendum because a lot of landlords have pushed back and said, I don't want to call it bed bug addendum. I present a bed bug addendum to a prospective tenant, and they're going to say, what, you got bed bugs? You know, the addendum that I've come up with, and I'm working in association with my associate Sarah Graham, who's here as well, in coming up with wording that works legally for the landlord and practically in terms of what you're going to be facing. I've seen some drafts of the addendum that we want to use that say 24 hours, 48 hours, but the point of the wording should be that the time limit should be very restrictive in terms of imposing an obligation on the tenant to advise the landlord as soon as they know of a bed bug infestation. A lot of tenants don't do that. A lot of tenants, again, they have to know that there's an infestation. A lot of tenants may not be aware that there's an infestation, but as soon as they have an idea or an inclination that there's a bed bug infestation, the addendum imposes an obligation to notify us immediately. Obviously, if you're going to remediate bed bugs in your property and you're a landlord and a tenant, you better do it right, okay? Spraying Raid on a bed bug is not going to kill it, okay? But a lot of tenants think it will. So we have to educate people. We have to make sure that the proper treatment is done. We have to notify the tenants in writing. We have to notify them, educate them on what the treatment process is, what they're required to do in terms of their part in getting rid of the bed bugs. And we have to make sure that they're aware, and the addendum has certain provisions in it that we've drafted that basically imposes penalties on them, ultimately leading conceivably to the eviction from the property and the forfeiture of their tenancy if they don't follow certain treatment guidelines and treatment procedures. Landlord should make sure that the tenant is given written notice as to what will happen if the tenant refuses to prepare the apartment or allow the entry into the unit. Was that it? Yeah. So basically, what we've done from a landlord's perspective for our clients is to get pest management plans and addendums out to them so they could make those documents a part of their lease documents. And a lot of landlords have done that already. They've come up with their own bed bug addendums or pest addendums, whatever you want to call it. Some are better than others. Some I'm not sure if they, without any determination as to causation, just blanketly put the cost of everything onto the tenant. I'm not sure technically that those are going to work, but certainly from my perspective and from our perspective at our firm, we feel that it's appropriate that if the tenant is not cooperating with the landlord in remediation and prevention efforts, that they be held liable for the cost of those items. Thank you.